Have you ever woken up one morning and discovered that something millions of Americans have legally owned for decades could suddenly become the center of one of the most important constitutional battles in the country? Because right now, that's exactly what's happening. And the next move by the Supreme Court could reshape the future of gun ownership in America for years to come. For months, legal experts, constitutional scholars, gun rights organizations, state officials, and millions of ordinary Americans have been watching a series of cases quietly moving through the courts. Most people never heard about them. They weren't dominating the nightly news. They weren't leading newspaper headlines. Yet behind the scenes, these cases have been building toward a moment that could have nationwide consequences. Now that moment may finally be here. The Supreme Court is once again being forced to confront one of the most divisive constitutional questions of our generation. Can states ban some of the most commonly owned firearms and magazines in America? Or does the Second Amendment place limits on how far those restrictions can go? The answer could affect millions of gun owners from coast to coast. And what happened inside the Supreme Court recently has legal observers paying very close attention. What makes this situation so remarkable is that it isn't simply about one state, one law, or one specific firearm. This battle reaches far beyond Illinois. It extends beyond California. In fact, depending on how the court ultimately responds, the decision could influence firearm laws in nearly every state in the nation. That is why both sides are treating this moment as potentially historic. Supporters of gun restrictions argue that states must have the authority to regulate weapons they believe present unique public safety concerns. They say communities should be allowed to decide what limits are appropriate to protect citizens and reduce violence. Opponents see it very differently. They argue that governments are attempting to prohibit firearms and magazines that millions of law-abiding Americans own for lawful purposes. They contend that constitutional rights cannot simply disappear because a particular firearm has become politically controversial. And now, after years of legal battles, those competing views may be heading toward a direct confrontation before the highest court in the land. The road to this moment began several years ago, when challenges to various firearm restrictions started moving through federal courts. As these cases progressed, states continued passing new laws, creating an increasingly complicated legal landscape. Some states enacted restrictions on certain semi-automatic rifles, others imposed limits on magazine capacity. Still others expanded existing regulations in ways that immediately triggered lawsuits from gun rights advocates. What followed was a legal tug-of-war that produced conflicting interpretations, passionate arguments, and intense scrutiny from constitutional experts across the country. Then came a series of lower court decisions that dramatically raised the stakes. Several courts upheld restrictions, arguing that governments possess broad authority to regulate particular categories of firearms. Meanwhile, challengers insisted that these rulings ignored the fundamental protections guaranteed by the Second Amendment. As the disagreement deepened, attention inevitably shifted toward Washington, because sooner or later, many believed the Supreme Court would have to step in. The question wasn't whether the issue was important enough. The question was whether the court was ready to take it on. For years, the Supreme Court repeatedly declined opportunities to directly address many of these disputes. Every time a major firearm case reached the court, Americans waited anxiously for answers. Every time the court declined review, uncertainty remained. That uncertainty has allowed states to move in different directions, creating a patchwork of laws across the country. In some states, firearms that are perfectly legal can be purchased, owned, and transferred without issue. Cross a state line, however, and those same firearms may face significant restrictions. For many Americans, that inconsistency has become increasingly difficult to understand. The situation became even more intriguing when several justices began signaling that the court might eventually need to provide clearer guidance. Those comments immediately sparked speculation throughout the legal community. Was the court preparing to revisit the issue? Were the justices waiting for the right case? Or would they continue avoiding the controversy altogether? Those questions remained unanswered until recently. Then something happened that caught the attention of court watchers nationwide. The Supreme Court reviewed several cases involving firearm restrictions and magazine bans during a private conference. While no final ruling emerged immediately, the court made a move that many legal analysts consider significant. Rather than disposing of the cases outright, the justices chose to take additional time. To the average person, that may not sound like much, but within Supreme Court practice, even small procedural decisions can reveal important clues. A case that receives additional consideration often signals that at least some members of the court believe the issues deserve closer examination. That doesn't guarantee the court will ultimately hear the case. It doesn't guarantee victory for either side. But it does suggest that the justices are taking a serious look at questions they have avoided for years. And that possibility alone has generated enormous interest. Because if the Supreme Court eventually agrees to hear these challenges, the resulting decision could become one of the most important Second Amendment rulings in modern history. The implications would extend far beyond the states directly involved. A broad ruling could establish nationwide standards that lower courts would be required to follow. States with similar restrictions could find their laws challenged. Future legislation could face new constitutional hurdles, and millions of Americans could gain much-needed clarity regarding what protections the Second Amendment does, or does not, provide. That is why this story matters. This isn't simply another political debate. It isn't another routine court case. It's a constitutional question that reaches into homes, communities, legislatures, and courtrooms across the nation. For supporters of gun rights, this could represent a long-awaited opportunity for the Supreme Court to finally answer questions that have lingered for years. For advocates of stricter gun regulations, it could become a critical test of how much authority states retain to regulate firearms in the interest of public safety. And for everyone else, it serves as a reminder that some of the most important legal battles in America don't begin with dramatic headlines. They begin quietly. They move through courtrooms. They develop over years. And then suddenly, one day, they arrive at the doorstep of the Supreme Court, where a handful of justices may determine the future direction of constitutional law for an entire generation. Right now, all eyes are on what happens next, because the next move from the Supreme Court could change everything. What makes the coming weeks so important is that the Supreme Court is no longer being asked to consider a theoretical question. The justices are being confronted with a conflict that has been growing larger every year. Across America, lawmakers, courts, gun owners, and advocacy groups are all interpreting the boundaries of the Second Amendment differently. One court may conclude that a particular firearm falls comfortably within constitutional protections, while another may view that same firearm through a completely different lens. The result is confusion, uncertainty, and a legal landscape that changes dramatically depending on where you live. For millions of Americans, the issue is no longer about politics. It is about predictability. People want to know whether the rights they possess today will still exist tomorrow, and whether those rights mean the same thing in every state. The debate centers around a simple but enormously consequential question. When the Constitution protects the right to keep and bear arms, what exactly does that protection include? That question sounds straightforward, but it has become one of the most fiercely contested issues in modern constitutional law. Supporters of restrictions argue that governments have long regulated certain weapons, and that modern public safety concerns justify additional limits. They point to mass shootings, crime prevention efforts, and the responsibility of elected officials to protect communities. On the other side, gun rights advocates argue that constitutional rights are not supposed to shrink when they become politically controversial. They contend that firearms owned by millions of law-abiding citizens cannot suddenly be excluded from constitutional protection simply because lawmakers dislike their appearance, capabilities, or popularity. What has elevated the stakes even further is the sheer number of Americans who could be affected by whatever happens next. This is not a dispute involving a rare or unusual product owned by only a handful of people. The firearms and magazines at the center of these cases are among the most commonly owned in the country. Millions of citizens purchase them legally. Millions more use them for recreational shooting, competitive sports, home defense, and other lawful activities. That reality has become one of the central arguments advanced by those challenging the restrictions. They argue that when an item is owned by millions of ordinary citizens for lawful purposes, it becomes difficult to claim that it falls outside constitutional protection. Meanwhile, states defending these laws insist that popularity alone cannot determine constitutionality. They argue that lawmakers must retain the flexibility to address evolving public safety concerns and respond to changing conditions. According to this view, the Constitution allows governments to impose certain restrictions when they believe doing so serves an important public interest. This clash between individual rights and government authority is precisely why so many legal scholars view these cases as potential landmarks. They force courts to answer questions that reach far beyond firearms themselves. At their core, these cases ask how constitutional rights should be interpreted in a rapidly changing society. Perhaps the most fascinating aspect of this story is that nobody outside the Supreme Court truly knows what the justices are thinking. Every action taken by the court is scrutinized for clues. Every procedural move sparks intense speculation. Analysts examine conference schedules, case histories, prior opinions, and even individual statements made by justices years earlier. Entire articles are written attempting to predict what might happen next. Yet the reality is that Supreme Court decisions often surprise even the most experienced observers. Cases that appear destined for review are sometimes declined. Cases that receive little attention suddenly become major constitutional landmarks. Until the court speaks, uncertainty remains. That uncertainty has created enormous anticipation throughout the legal community. Attorneys on both sides understand what is at stake. Advocacy organizations are preparing for multiple possible outcomes. State governments are monitoring developments closely. Lawmakers are watching to see whether existing statutes may eventually face constitutional challenges. Even lower courts are paying attention because a major Supreme Court ruling could fundamentally alter how future cases are analyzed. In many ways, everyone is waiting for direction from the nation's highest court. For gun owners, the uncertainty can be particularly frustrating. Many feel trapped between conflicting legal standards. A firearm that is completely legal in one jurisdiction may face restrictions in another. A magazine that can be purchased freely in one state may be prohibited in the next. This patchwork system has fueled calls for a definitive answer from the Supreme Court. Whether that answer ultimately favors broader protections or greater regulatory authority, many observers believe clarity itself would be significant. After years of litigation and conflicting rulings, people simply want to know where the constitutional lines are drawn. But there is another reason these cases have attracted so much attention. The Supreme Court rarely takes Second Amendment cases. When it does, the consequences are often profound. A single ruling can reshape legal doctrine for decades. It can influence hundreds of future cases. It can affect legislation across the country. And it can redefine how courts evaluate constitutional challenges moving forward. That is why every development, even seemingly minor procedural updates, generates headlines. Everyone understands that if the court chooses to fully engage with these questions, the eventual decision could become one of the defining constitutional rulings of this era. As the next conference date approaches, speculation continues to grow. Will the court agree to hear the cases? Will the justices decide the issue requires further review? Or will they once again decline to step into the debate? At this stage, nobody knows. What we do know is that the legal battle is far from over. The arguments are becoming more intense, the stakes are becoming clearer, and the nation is moving closer to a moment that could determine how the Second Amendment is understood for years to come. The coming months may not simply decide the fate of a few state laws. They may help define the relationship between constitutional rights and government power in modern America. That is why millions of Americans are watching so closely. Because when the Supreme Court eventually makes its move, the impact could extend far beyond any single courtroom, any single state, or any single law. It could influence the constitutional landscape of the entire nation.